Hi there, I'm Savannah Mexto from Mannor Law Group, and I'm excited to welcome you to another Webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. Today, we're talking about blended families. Combining family financials can be complicated, but blended families face even more complex planning issues. When one spouse passes away, many families without targeted planning may find themselves sifting through a mess of drama and legalities. On this week's Webinar Wednesday, attorney Bob Mannor will discuss how to avoid these blended family planning issues and ensure this process is fair and as easy as possible for all of your loved ones. Now, before I pass the mic, I'd like to cover a few housekeeping details. First, even though attorney Bob Mannor is an attorney, this webinar will not give specific legal advice. If you do have a question about your unique situation, I encourage you to contact us after the webinar. Also, if you have a general question today during the presentation, please use the question box. We will save time to review questions during the webinar, but if for some reason we don't get to your question, we will contact you after the presentation. Also note that today's presentation will be recorded and the replay will be sent tomorrow. So if for some reason you're pulled away or distracted, you can rewatch, and you can also share this information with family or friends. Now, why should you listen to what the folks at Mannor Law Group have to say? First, note that we're nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, my personal favorite reason, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Mannor.
Hi, folks. This is always a really interesting topic, and it actually is very important from the standpoint of it is really easy to have bad estate planning when you have a blended family, meaning that not all the children are from the same parent. And so I thought this would be a funny analogy to say, you know, I'm not sure where Disney came up with the idea of the evil step parent or the evil stepmother, whether it was really an evil step parent or whether it was just bad estate planning. And I think a lot of times it was the bad estate planning. And I see this very, very frequently. And I talk to families all the time. Through the years, I've gotten to talk to a lot of families, and almost anybody I talk to, when I raise this particular issue, they'll know of somebody. They'll have somebody that they'll know of where it went poorly, some part of it, some element of it went poorly when there was his kids and her kids. And that the things didn't go the way that they thought it should. And often that is involved in the planning was really not done well. And so when I mention this to folks, when we're talking about this particular issue and we're mentioning this to folks, they'll often say, oh, well, you know, and they'll kind of reference the step parent as being not a good person. And I try to give them some benefit of the doubt and say, okay, well, it could have just been by operation of law. It could have been by operation of law that things didn't go the way they were supposed to. It really wasn't necessarily intended by dad or by mom or by stepdad or stepmom. It was just that wasn't how it was expected was going to happen. So I was meeting with a couple recently. We were doing a remote meeting because we're doing a lot of remote meetings these days. And so I was talking to them like this over the computer, and they had been married for 25 years or something like that. And the husband was actually, you know, going through some medical issues, and we talked about it, and they said, well, this is what's going to happen, you know, when I die, when both of us die, this is how everything's going to be divided up. And I said, well, no, that's not going to be the way it goes. And they said, no, that's what we want. When we've told everybody that's what we want, this is what's going to happen. This percentage is going to go to my kids, and this percentage is going to go to their kids, and this asset's going to go over here, and this asset's going to go over here. And I said, well, but no, it's not going to happen that way. And they said, but no, it is, because I just said so. And I said, it doesn't work that way. You can't declare it to be so and make it work that way. Operation of law is going to cause this. So let's think about it. Whenever we try to think about these things, when I'm going to bring you over into my world a little bit and bring you over into the law a little bit. And the idea of thinking about it from the standpoint of the law is to say, well, okay, well, what will make it happen that way? Who will enforce it? Who will make it happen that way? And the bottom line is, it's the law, and it's the courts, or it's the contract law that, trusts are basically contracts. And so that's what's going to make it so. So just declaring it so it isn't going to happen. So here's what typically happens, because this is why it goes wrong so often. Typically, people that are married for some period of time are going to want to make sure that they're caring for each other. And that's often one of their primary goals. Is, of course, they want to, preserve what they can for the kids, but they want to care for each other first. And so they say, well, boy, if I die first, I want my spouse to have a place to live. And boy, if I die first, well, what if they need money? I want to make sure they have money. So we tend to change beneficiary designations, or have joint property and things like that. And they think just because they have this will, or even if they have this trust, or even if they have a prenuptial agreement, they think that those are somehow going to take precedence over the fact that everything is going to go to the surviving spouse, or maybe not everything, but a lot of it's going to go to the surviving spouse. And so they say, okay, well, my will says everything goes to the surviving spouse. What does that typically mean? Typically, what that means, if we don't have any planning beyond that, is that all of the assets will eventually go to the surviving spouse's kids. And the first spouse to die, their assets will, their kids will not get anything. And that's just typically the way that it works, because it's not as though the surviving spouse, I think a lot of people would say, well, that's right. We wouldn't want the surviving spouse to be kicked out of their house. We want them to have a place to live. We want them to have the, the comfort that they had as a couple for 25 years, 40 years, how many ever years it was. They, we're not going to impoverish the surviving spouse because the first spouse died. We're not going to distribute the assets out to the kids upon the death of the first spouse. Typically, that's the that's something that the both spouses wanted, especially if they were married for some time. So think that through, though. What does that mean then? Well, so the first spouse died, their will no longer has any precedence. Their will no longer takes effect, and because everything, their will just says everything goes to my spouse, my surviving spouse. And so when the surviving spouse dies, unless they have proper planning, it's typically going to go to their kids, okay? And one side of the family gets cut out completely, often unintentionally, all right? And so this is just the way of operation of law. That's the way the law works in most states in the United States, if not all states. There's a little bit different law in Louisiana than the other 49 states, but I still think even in Louisiana, that's the way that it works. And so in the United States, I know this is different in other countries, but in the United States, you get to determine what happens to your assets, okay? There is no standard that it has to go this way. Sometimes kids don't understand that. Sometimes kids think they have an expectation of getting an inheritance. They say, by the fact that I'm a child, I get an inheritance. Well, that's not accurate. You don't have the right to anything as a child. It's not your right. Now, if parents haven't done planning, then yes, there's a default. There's default rules that say, okay, well, it's going to go to the if there's no spouse, and it's going to go to the children of the decedent. And so that is the default, but you can plan around that very easily. You can have your will plan around it. You can have a trust plan around it. You can use beneficiary designations or joint ownership that will plan around it. And so sometimes people think that everything's going to be fine because they just assume that they have this will that was drafted up 27 years ago, and that's going to somehow solve the problem. Well, but that's not the way people typically operate, because they will often, in their later stages of life, they'll put beneficiary designations on their account. Well, that's going to take a precedence over the will. They're going to put joint owners sometimes, a lot of times just for convenience. So they say, oh, well, it's my granddaughter that helps me go to the grocery store, so I'm going to put my granddaughter on these accounts, and well, she's going to have to follow the will, right? No. Granddaughter gets it. If her name's on the account, she's going to get it. And there is certainly no guarantee that she's going to divide it up or has any legal obligation to do so. Now, sometimes that can be disputed in court and things like that, but there is no obligation. There's no legal basis for someone to say, I have a right to an inheritance, because you don't. You don't have a right to an inheritance. So let's divide this up a little bit, because there's really three different scenarios. So the three different scenarios with the blended family is we're going to have some couples that keep their assets completely separate. Okay, we got his assets and her assets, right? Then we've got some couples that everything's joint, everything is commingled, and then we have the majority of couples that have some combination of the two. And that's the most common scenario, is there's some combination of the two. And the reality is, even those couples that set out to have everything separate rarely do. I can't count how many people have come in where they had a later in life marriage, and because it was a later in life marriage and they already each had kids and their kids were grown and they each came into the marriage with assets, that they appropriately did a prenuptial agreement. And people think, oh, well, prenuptial agreement, that's the answer for everything. Unfortunately, no. In fact, we don't do a lot of prenuptial agreements because they only work if you use that tool properly. Because what typically happens is we do a prenuptial agreement, and then 5 years after we get married, we say, oh, well, oh, I noticed your name's not on the house. I better put your name on the house, or let's buy a house together. Oh, well, we have a house together now. We better have a joint bank account together. Okay, now we have a joint bank account together. Oh, I noticed you're not on my 401k. You're not the beneficiary on my 401k. Well, we've been married for 25 years now, and so my goodness, if I die, I wouldn't want you to be without that money. We kind of rely on that 401k, the distributions from the 401k. So I better list you as the beneficiary on my 401k, right? Okay, well, yeah, and that's what happens over time. And that we're pretty much might as well just tear up that prenuptial agreement, because it means nothing. The prenuptial agreement is only if the assets are maintained separately. So the only way to really maintain assets separately, and honestly the best way to maintain assets separately, is each spouse has a trust. That's going to be so much easier to be able to manage it, maintain a house together, maintain accounts where there's going to be access to the money as needed, but that ultimately it's going to go in the direction that it's supposed to go in. So each spouse has their own trust, and the assets that, and we might even be able to set aside the assets and say, okay, well, I want to make sure that my spouse, whichever spouse is the surviving spouse, they have access to this money if they need it. But if they didn't need it, if it's left over, that it's going to go to my kids, and the other spouse would have the same issue. And as far as the house, maybe they own the house together. Well, one trust owns half the house and the other trust owns half the house. That way, then we can make sure that both sides still get it. But that's not what most people do. That's probably good planning, but that's not what most people do. Most people, they maybe did a prenuptial agreement. Well, that prenuptial agreement's out the window as soon as you start commingling assets, as soon as you start changing beneficiary designations, as soon as you start putting names on each other's accounts, or you buy joint assets like a house together or something like that. And so that's option number one, is we keep the assets separate. And the reality is that's a great idea. It's just most people they move away from that the longer they're married. It's a good idea. That way we can have the trust make sure you're protecting each other. We can have the trust say that the surviving spouse has the right to live there, has the right to sell the property and buy new property, has the right to use the money as they need it for their needs, their health, education, maintenance and welfare. But whatever's left over, what the one spouse came, into the marriage with is going to go to their kids, and what the other spouse came into the marriage with is going to go to their kids, and that's going to be the cleanest, neatest option. It's just often not what people do in real life. And so if we can organize it that way and set it up that way, that's great. It's just I rarely see people come into the office. They might leave the office with that kind of a plan, but they rarely come into the office that way. As often as not, there's many families out of necessity as much as anything else, because many of us don't have millions of dollars. It's not going to be that each of us have millions of dollars to set aside. So for a lot of folks, of course, they're commingling assets because they need the assets to both live on. And so they have the commingled assets, they have the joint accounts, they have each other as beneficiary designations, and that's the way that they live, and that's the way that they've always lived. And a lot of the families will then say, okay, and then we're going to divide it up between the 6 kids. I've got my next graphic, I put the Brady Bunch on here. So for people my generation or older, you'll remember the Brady Bunch. If you're younger than me, you may or may not remember the Brady Bunch. But the idea is that for many people, that they're just going to treat everybody equally, all the kids equally. Sometimes what they would do is they'd say, well, you know, she has 4 kids and he has 2 kids. And so we're going to divide it 50-50. 50% is going to go to his 2 kids and 50% is going to go to her 4 kids, or however you want to divide it up. You have all of those options if you do proper planning. So a lot of people come into the office and they already have commingled everything. It's that ship has sailed, whether they had a prenuptial agreement or not. That ship has sailed. They've already made everything joint or have each other as beneficiary designations. It's everything's commingled. And so that's the more that's you know, that's where we get a little dicey, and trying to make sure that we protect everybody's interests and try to make sure that we don't accidentally or on purpose disinherit any of the children that wasn't agreed upon by both parents. And so that's one of the things where a trust is really going to be a much better option than a will. We had a will come into the office the other day, and it was an attempt at they had an agreement not to revoke their wills. And this is a very old-fashioned technique that some lawyers thought about probably in law school and thought about it from a book learning kind of way, but is completely impractical from a real life standpoint. And one of the things that we try to do, and it's part of the advantage that we have as lawyers that help people not just prepare for the future, but actually help them when the time comes, when the death comes, when the crisis comes. We're hand in hand and helping folks through that process too. And so we see how these documents actually work, and we think about how they work from a practical standpoint. And an agreement not to revoke your will, it's so convoluted and is almost impossible that it's going to be a practical solution, especially in the case that we had, because it attempted to create a testamentary trust and all these other things that were near a legal impossibility. So the idea is, if we're going to have everything joint, all right, then we have to really think through and have clear terms to say, all right, well, what does that mean when one spouse dies? Are we going to then have a co-trustee with the spouse? Are we going to trust the spouse and not have a co-trustee, but make it so they can't change the terms of the distribution, that they can't cut out the first spouses? Well, the problem with that, of course, is that then you could just say, all right, well, we have this trust, and the surviving spouse is the sole trustee, the only trustee. And in terms of the trust, so you can't change who gets what after the death of the first spouse. Okay, well, then you could just take all the assets out of that trust and create a brand new trust. So really, it can be difficult in that scenario. And the only real practical way of enforcement is to have a co-trustee on there that would make sure that the surviving spouse doesn't just take all the assets out. What most couples do, to be honest with you, because they don't want to leave their spouse with a co-trustee that's going to be not their child. It's going to be the child of the first spouse to die, because most families don't want to do that. They don't want to burden their spouse with having somebody have veto power about how they spend their money after their death, after the first death. They just trust each other, which is of course dangerous, because it's not. Part of it is, well, maybe, you know, some people aren't trustworthy. Let's be honest. Some people will hold grudges, and some people would say, well, as soon as my spouse dies, I'm going to cut their kids out. I'll agree to it now, but as soon as my spouse dies, I'm going to cut their kids out. That's a reality. Some people are like that, right? But the bigger reality is that as we get older, especially if we're ill or sick or have any form of memory loss or dementia, we're much more persuadable, let's say. We're much more easily influenced. And so this is why you see all the times where sometimes you'll have a caregiver who convinces a person to change their documents. Now, is that going to be legal? Maybe not, but then you still have to say, okay, well, that's not legal. Okay, prove it. That's one of the things bringing you back over into the lawyer's analysis here. It might be, yeah, you shouldn't be able to take somebody who has dementia and have them sign a whole new will or a whole new trust. You shouldn't be able to do that. But okay, what's stopping you? What's stopping you? How are you going to fight that? And there's really two ways to fight it. First of all, you gotta go into court, right? You gotta go into court, because how are you gonna fight it if you don't go into court? So somebody gotta bring it into court. And then there's really two legal analysis as to say, well, that's not a valid document. One is to say the person didn't have legal capacity at the time that they signed the document. The second is to say that they were unduly influenced, okay? And so it's, oddly enough, it's actually a lot easier to prove undue influence than it is prove lack of capacity. These are both very difficult things to prove. So the thing on this is to say, okay, well, boy, that should be illegal. Well, maybe it is illegal, but it's also hard to prove. And it means hiring lawyers and going into court and going through that whole process. And so sometimes it's better to have the legal mechanisms in place. This is why having two trusts, one for each spouse, is going to be much more enforceable, much more solid, and much more stable than having one joint trust in a situation of a blended family. Now, if it's not a blended family, if all the kids come from both spouses, then I almost always am going to do a joint trust. That's almost always what I'm going to recommend. And I'll be honest with you, most of my clients end up with a joint trust, even with a blended family, because they've already commingled their assets, and we're building in some kind of form of confidence and trust, and we build in, maybe we have the successor trustees, one from each side of the family, those types of things. So we try to build in some checks and balances in there. So the ideal is that each spouse has their own trust if it's a blended family. Most people don't choose the ideal because it's more expensive, it's more complicated. We got to keep the assets separate. We got to, keep them, keep them organized and things like that. And most folks want simplicity, which that's a big factor in this, right? We got to have this be easy to live with, right? And so that's the second possibility. So the first possibility is you kept your assets separate. The second possibility, which a lot of people do, is everything's basically joint. And then the third possibility, which is extremely common, which is that most of the assets are joint, but some of the assets are separate. This is even more complicated. And the reason it's more complicated is because people think, okay, well, I inherited this one account from my mom, and so that one account is going to be go to my kids directly. Everything else is joint, and it's going to be divided equally. Or they think that's the way it's going to go, but they want that one account that they inherited from their parents to go to their kids directly. That's okay, but the thing is, we don't know what tomorrow brings. We don't know what next year brings or 20 years from now brings. Are you still going to have that exact account at the time that you die, when you're 89 years old or 95 years old or 103 years old? And my belief is, my educated guess is, that if you live that long, the answer is no. You will not have those same accounts. There'll be reasons why things got consolidated. There's going to be reasons why things got moved around and consolidated, made easier to keep track of, all those types of things. And sometimes it's after you are no longer personally in charge of things. Now, I know not everybody likes to think about it that way, but the reality is most of us are going to have some period of time before our death that we're relying on somebody else to help us make decisions. That's just true. That's just true. Most of us, we'd love to be able to say, I'm going to make decisions for myself until the day that I die, and the second that I die. It's just not realistic for most of us. Certainly it happens for some, but that's very rare. And so somebody else might be consolidating those assets or making it easier to manage or those types of things. And so when we try to set aside one asset and say, well, this particular asset's going to go that way, the better answer again is probably going to be a trust, because with the trust, what we can say is, well, it's not about this particular asset with this particular company and this particular account number. It's going to be, I want approximately this percentage of the assets to go only to my kids, or I want this percentage of the assets to go only to my spouse's kids. That is so much easier, so much more thorough, so much more enforceable, so much more likely to actually be followed, and to do it as a percentage rather than a dollar amount, because we don't know what dollar amount you're going to have when you die. So it is even more complicated when we have some joint assets and some non-joint assets, and our intention is some of them are going to go equally to the kids and some of them aren't going to go equally to the kids. The best answer for that is simply a trust. I know it seems like I'm a broken record and I'm always saying this, but the whole concept of a trust, if you don't know what a trust is, it's just a contract. And the good thing about a contract is we can put details, we can have specificity, we can have contingencies. We're going to say, well, what if this happens, and what if that happens, and what if this happens, and what if we use it for this first, and then after we're done using it for that, we use it for this. We can go into great detail. This is why trusts are so long. People complain, they say, oh, my trust is 90 pages long. Good. Good. That means we put some detail in there. That means we did it. I mean, it doesn't mean it's just because it's long doesn't mean we did it right, but it means that there's detail in there to address that. And this kind of goes to another issue, which is if your lawyer isn't listening to the specifics of what you want and they're just drafting some form document, you're also not going to solve that problem, because this should be customized to what your needs are and what your circumstances are. And if the lawyer is just using some form document, or you downloaded some form document, you're absolutely not going to be able to accomplish this with a joint with a blended family. The final thing I want to talk about as it relates to blended families is the issue of long-term care. And so a lot of what you probably came here to think about was, well, what happens after somebody dies? How do we make sure there's a fair distribution? And many people aren't thinking about it from this element. But the truth is, this is as much of a difficulty, and probably more of a difficulty than anything else, because so this gets so messy, especially if one spouse came into the marriage with a lot more money than the other spouse. Well, in Michigan in particular, spouses are responsible for their spouse's long-term care needs. And so if we're in a nursing home that costs $120,000 a year, or if we're in home care and we have to pay for 24-hour home care, it costs $10,000 a month or whatever it's costing, then if one came into the marriage and didn't have any money, the other one's expected to spend the money. They're not, you can't, when we look at government benefits like veterans benefits or Medicaid and those types of benefits, they're going to look at the joint assets of both spouses. They don't care about prenuptial agreements. Sometimes people come in with prenuptial agreements that will say, oh, well, I'm not responsible for my spouse's medical expenses. And we go to the Medicaid office or the VA office, and they say, well, that's really cute, because we don't care what your prenuptial agreement says. You're responsible. Now, there's certainly ways that we can protect the spouse. That's what we do in our office. We protect folks and we protect assets and still qualify for veterans benefits and still qualify for Medicaid, whether it's home Medicaid or nursing home Medicaid. And there's lots of spousal protections that we can invoke in the law, built into the law, and we can definitely protect assets and qualify. But if you haven't done planning and if you haven't thought this through, so one of the things when it comes to planning for long-term care for a blended family is ideally actually including the children in that conversation. And that's kind of a difficult thing to do, because none of the kids like to think of their parents having to need long-term care or maybe having memory issues or anything like that. We just don't like thinking about our parents that way. But the reality is it's really helpful if we can bring in both sides, because so many times it creates this big family conflict, because one side's just trying to make sure that we're protecting assets and that we're making sure that the one spouse is getting the care that they need and the other spouse isn't going to go broke as a result of it, which is a perfectly good and legal thing to do. And that's what we do for folks. That's what we help people with. But the other side of the family sometimes gets really upset about it because they think that somehow that, you know, we're stealing money or hiding money, which is not the case. We never hide money. It's not something we do. We legally protect money, and we still protect the spouse, make sure they're not going to get impoverished because of their spouse's care needs. Okay. But it's best if we can include both sides of the family in that conversation. If we can't, there's almost bound to be miscommunications on that. And that's unfortunate because it's unnecessary. I'm going to go back to my evil stepmother, evil step parent slide. I think a lot of this that's involved in this is miscommunication. And it's not understanding how the law works and not understanding what the expectations are and what's going to happen if you don't have proper planning. And even lawyers sometimes don't plan particularly well for blended family situations. Lawyers sometimes rely on, you know, putting round pegs in square holes kind of a thing. They treat everybody the same. And so an office like ours, where we never treat everybody the same. Everybody has customized planning specific to their particular needs. And when it comes to a blended family, a lot of it's about communication. It's one of the reasons why we have ongoing communication. We have education for the family. We just recorded our family education workshop that is designed to educate the kids, not our clients, but the kids of our clients. We do our annual meetings to make sure that people are up to date and understand what their documents are and if there's any updates that they need. And it is a lot about communication. And it's unfortunate because a lot of these issues, it comes down to if we can all just sit around a table and talk about it, and not just sit around a table and talk about it, because a lot of times if you have warring parties or people that are fighting with each other sit around a table and talk about it, you're just going to get a lot of folks giving their own thoughts or their own advice or what their neighbor told them or what their barber told them. It's the idea of having it guided by the lawyer who knows what it's actually going to happen. It's like the conversation I started with when I told you about the family that I was talking to, and they said, well, this is what's going to happen. And I said, no, it's not. That's not going to happen that way because your legal documents don't say that, and that's not the way it's going to work. You might declare it to be so, but it doesn't work that way. So having somebody guide that conversation and being able to, you know, talk to both sides of the family and make sure everybody understands in a very calm and easy way and kind of show the path and say, yes, there is a path to make sure everybody is treated fairly, make sure that everybody is treated, that you know, people get the care that they need, that we're not going to impoverish one of them, that the kids are going to be treated the way that the parents wanted them to be treated, and they're going to get the share that the parents wanted them to get. That's all possible. And it's even better if we can, you know, communicate about it. And so that's just one of the things that kind of distinguishes real lawyering and real planning from just kind of cookie cutter fill in the blank kind of thing, which there's a heck of a lot of out there, whether it's within a lawyer or not with a lawyer, which is unfortunate. But the bottom line is when it comes to if it's his kids and her kids, you really do have to make sure that this is thought through, it's discussed, we've thought about the pitfalls that are out there, and we've addressed them. So let's see if we have any questions, Savannah. Otherwise, Savannah's going to give you some instructions about how you can get a hold of us, and we can help your family get through these things.
Thanks, Bob. I don't see any questions, so if you do have a question, I encourage you now to go ahead and place that question in the question box. I've gone ahead and in the chat box, I've put a link, and this is a way for you to actually get in touch with our team. So maybe you have a question, but it's really complicated and you don't want to ask it on the webinar, or maybe you just would like some more time. So there's two ways to get a hold of our team. First, you can use the link that I've just put in the chat. When you click that link, it's going to take you to a calendar. You will choose a day and a time that's convenient for you when a member of our team can give you a quick call. This call will last at most 15 minutes. It will give you a chance to ask questions about our firm, about our process, maybe even about some of the information that you've heard today. And it will also give our team a chance to ask you questions about your situation and your concerns. And we can really get a feel to make sure that this is something that we can help you with and that we're the law firm that you would like to work with. So I do encourage you to go ahead and click the link and schedule that. Now, if for some reason you want to talk today or like, I don't want to mess with the calendar, I just want to call, you can do that too. You can give us a call at any time. Our phone number is 810-694-9000. And I've just gone ahead and put that in the chat box as well. So again, you can click the link and schedule a time, or you can call 810-694-9000. Thanks again, everyone, for joining us today. We look forward to seeing you next week.